Hey, ladies and gentlemen, welcome to another episode of our Property Law Alliance. We've got a special guest today. We're joined by Alicia, who is from the BSA Conveyancing and Real Estate Department. I think we are on episode 132 today, I believe, and we do have two questions today. We're going to start with our first question. We're going to get right into it. This one will be for Bruno, and this one deals with specifically a pensioner who wanted to request information regarding trusts and a form. The second question rather will deal with property and municipality property evaluations. Bruno, I'm going to read out the question for you quickly, and then you will be able to just give us the answer regarding what we can gather from the question. Okay, this one is from Sita. Sita gives us a situation here whereby she says that a pensioner is on an endeavor to have a trust registration certificate reissued and approached a law firm to assist with this application. He was then issued with a blank form titled Annexure H, and it said information required for trusts, right? He then signed the blank form and submitted it to the law firm. And on his second visit to that law firm, the said Annexure H, right, was populated with information which he did not personally fill in, right? So the form then had extra information. So yeah, now he wishes to then retrieve the original Annexure H, right, which are the signed and populated one, as he is of no information, as he is of the view that he made a mistake by signing and submitting a blank form, which contained contents which he was not aware of. And then his question here, Bruno, is then what sort of recourse does he have at their disposal regarding this specific situation whereby he signed a form and he wasn't aware of the contents as the form was blank?
Sure. So unfortunately, I think there's bits and pieces of information missing here. So it's going to be extremely difficult to answer this question properly. I'm going to try cast the net as wide as possible and to try to cover as many possible contingencies or scenarios. But yeah, I might be completely missing it, or I might hit the nail on the head. So if we first start with the fact that he was looking for proof of trust registration, if I'm not mistaken. So he wanted proof of a trust registration certificate, right? Now, so already over here, we've, we sit at 4, because on the one hand, is it his own trust? Is it another trust? Annexure H or a Annexure H is, it's all over the place. So there's nothing specific, no specific Annexure H's when it comes to trusts. Nothing in the Trust Property Control Act requires an Annexure H. Yes, the Master of the High Court has certain documents that need to be filled, not usually Annexure H's or Form H's. But I mean, it's all over the place. I know that the Reserve Bank has certain tax things when it comes to containing Annexure H. I know when you buy properties, for example, one of the basic attachments to when you're signing body corporate rules, I've seen a few agencies refer to it as Annexure H, but that's unfortunately that kind of puts me in a bit of a uncertain environment, because I'm not sure what Annexure H the person's referring to. A trust, fundamentally, that's registered with the Master of the High Court, in order to be properly registered, would have to have a letter of authority, right? So this LOA would basically, long story short, would be confirmation that the trust has appointed trustees, and these trustees are allowed to act on behalf of the beneficiaries. So that's already the first thing to look out for. So if he's looking for proof of registration of his own trust, or proof of registration of a trust where maybe he's a beneficiary or he's getting involved in, or whatever the case is, it's simply a matter of acquiring that letter of authority. Now, if you come to us as a law firm, or you come to Intergen and you ask us to acquire that for you, Yes, there's certain information we'd ask you to fill in, our own mandate, basically giving us instructions to act. And there would be a request form that would go to the Master of the High Court, asking the Master to give us a copy of the letter of authority. That is definitely a possibility. Now, I'm not sure about the question where he signed it, it was blank, and now it's got information. If it's simply a request form, that wouldn't be all that damaging. If he is worried that he signed something other than a request form, my suggestion is to approach the law firm and demand a copy of the document that you signed, and just verify what that document actually is and what it relates to if you are worried that you signed something and you didn't know what you signed. If for some reason the attorney doesn't respond to you, the other solution is to approach the law society and ask compel the law society, or rather ask the law society to compel this particular attorney to supply you with the documentation. Getting a letter of authority from the Master of the High Court shouldn't be a challenge. It's only a challenge because the master takes so long. But from the attorney's side, it's quite simple to get the necessary information and go to the master and request the necessary information. So yeah, that's the long answer to what I hope the right answer to that question.
Yeah, no, thank you, Bruno. I think as vague as the question is, you seemed to have at least covered a big part of it with regards to any type of recourse that she might have in this situation. So yeah, thank you very much for that. And we do hope that Sita is covered with regards to that. Of course, she can obviously, if she needs any more information, please feel free to send us a message and we will provide you with details as to how you can get in touch with us and we can have a look at that matter with more specifics, of course. So